Start. So good afternoon all and welcome to the latest Training and Manufacturing Group webinar. My name's Laura Jones. I chair the Technical Partners Group currently of the Training and Manufacturing Group. And before I hand over to Julia Fitzsimmons, who is Head of Employment at FBC Manby Bowdler, one of our technical partners, I just wanted to take the opportunity to run through a few slides as a bit of an introduction to TMG, albeit I think most of you who are here are actually members or involved already. So I hope you don't mind me just taking a few moments out to do that now before we commence. So bear with me if I can just share my screen. Which hopefully you can all see. So just a bit about the Training and Manufacturing Group, which was formed in 2015 to support SME manufacturers with access to technology and training, along with business support. Our aim is to really improve productivity for members, help them develop new products, work with them on efficiencies and cost savings, and boost their skills. We have 7 technical partners who work collaboratively to provide this support, all of which are named in this slide. So you can see we have ETG, Boromat, FBC Manby Bowdler, Hexagon, Goering, BDO and Incom. So they all offer their resources and expertise in advanced tech, upskilling, product realisation, as well as professional services as well. And hopefully many of you have already joined previous webinars and heard from a number of our technical partners already. And the final slide, and most of you will already be aware of what you get access to as a TMG partner. So all of these benefits listed here. Obviously, if anyone has any queries or any membership kind of inquiries, questions, Cassie's your go-to, who's here on the call somewhere, albeit you can't see her at the moment. So that's just a really brief update on the Training and Manufacturing Group. Obviously lots more info available on the website. We're also really active across social media, so please follow us on Twitter or join us on LinkedIn to access information, updates, anything that affects the sector. And that's it, thank you very much. So I will now hand over to Julia, who's going to take you through the employment law and HR presentation today. So just bear with me and I will switch slides. Julia, over to you.
Hi, good afternoon everyone. We're going to be looking at the topic of redundancy today. So first slide to look at what we'll be covering. So if we could have the next slide. We'll be looking at what do we actually mean by redundancy, because sometimes redundancy can be used by employers quite broadly. So what's actually the legal definition? We do need to make sure that the action we're taking actually fits into that. When do we have an obligation to inform and consult collectively? How can we act fairly so that we can minimise any unfair dismissal claims? What alternatives would any employment tribunal expect us to look at before we take the step of making somebody redundant? And then looking at the statutory and contractual payments that individuals are entitled to and the tax treatment of those. So if we look at the next slide, then the definition of redundancy. So it's set out in the Employment Rights Act, and the first definition is one that I think that we'd all understand and most employees don't usually take issue with or have a problem with, is when there's a business closure. So if the business is actually closing down, then that is section 139. If an employer is ceasing or intending to cease to carry on business for the purpose for which the employee was employed by it. So it's a fairly simple definition there. If the business is closing, that's fine. Second section, workplace closure. So if the employer is ceasing or intending to cease to carry on the business in the place where the employee was employed. So not necessarily a business closure, but just a site closure. That can also be an area that sometimes trips people up, because site closure, workplace closure also means site relocation. So sometimes that's where we get some crossover, that there may be an obligation to inform and consult both individually and collectively if we have a site relocation, because one workplace is closing just because another one is reopening, and everyone is being offered perhaps new employment at the new site, still means that we would have to go through our individual and collective consultation obligations. And then the final definition on the next slide is where we don't need the number of employees that we currently have in order to carry out a particular job role. So if we've got a reduced need for employees of a particular kind at that place of work. So those are the three occasions on which a redundancy can occur. Either the business is closing down, the site is closing down, or we need less people to do a particular job. Okay. So when would we, in those circumstances, then need to consult collectively? Well, that is when we've got more, when 20 or more employees are being made redundant over 90 days, and that's when our obligation under the Trade Union Labour Relations Consolidation Act comes into play, and we have to consult collectively as well as individually. So if we look at collective consultation first on the next slide, this means that we've got to inform and consult appropriate representatives. So it would be looking to see who those would be. If, as an employer, we're unionised, then it would be the trade union representatives. If we're not unionised, and a lot of places aren't these days, then you would need to have worker representatives in place. Sometimes worker representatives are already in place on workplace forums or workplace committees and already have a mandate to be able to negotiate or represent their various constituents in collective consultation negotiations. But otherwise, you may have to choose them for this particular purpose. So usually this is done in large groups at a town hall style meeting, where the fact of the proposed redundancy is told to everyone, and you can then split up the workplace into the various different components. It might be night shift, it might be admin, it might be engineers, or whichever sections would work best for the employer, and you ask for a number of representatives from each of those groups. So you may want 2 or 3 from each group, so that you've got a manageable committee to work with. You don't actually have to go to an election unless you're in the position where you get more volunteers than you actually need. Sometimes employers decide to accept all the volunteers, as I say, unless it gets too unwieldy. But otherwise, if you have more volunteers than you need, then you'd need to go through an election process, and all that needs to be taken into account because it impacts on your time frame. Because point 2 on the slide, where we've got 100 or more redundancies, then a consultation needs to take place at least 45 days before the first dismissal, and if it's less than 100, 30 days. So the 30-day or the 45-day clock won't start until you can start consultation, and you can't start consultation until you've got your reps in place. So it's not 45 days from the decision and informing all the members of staff that's the proposal. It is 45 days from meaningful consultation. So again, if you were looking at a larger scale project, you would need to build that into the time frame. The next obligation, then, you've got to notify the Secretary of State on a form called an HR1 form, which basically requires you to set out the basic details and the time frame and whether worker reps are in place. and that notification must go to the Secretary of State 45 days before the first dismissal, or 30 days before the first dismissal, depending on the numbers. And just a point on the numbers, because I do get asked this quite a lot. Sometimes the numbers develop as time goes on. That initially, some employers might decide that they need to make 10 people redundant, and then subsequently another 10, and that would take them over the 20, and might mean that then collective consultation kicks in. It really is, in those circumstances, a sort of a matter of fact in each case, whether the proposal was to make the 20 people redundant in the first place, and some employers might look to break that up to avoid collective consultation. So it is about say really what the proposals were from the outset, and documentation and board minutes, and internal communications might have to be disclosed there to prove the point one way or the other. So, and also included in the numbers, in the more than 20 to get you into the collective consultation bracket, would be people whose contract hasn't been renewed. So if you have fixed term workers who are let go during that period, and people who leave, say, under a settlement agreement, they would also come into the headcount for whether collective consultation was necessary or not. Okay. So if we look at the next slide, then if we don't get our information and consultation right, then a tribunal can make an award to each of the affected employees, and that they start at 90 days. So the tribunal would start at awarding an employee 90 days and pay, and that would be actual pay. Yes, actual pay rather than any statutory limit. So they'd be looking at making an award of 90 days pay for each employee. And then as the employer, it would be our job in the tribunal to try and persuade the employee to come down from that figure. So 90 days is the starting point, and then it's providing evidence to try and talk that figure down. So it can be quite costly if we don't get our collective consultation quite right there. And of course, then there's a fine as well if you don't notify the Secretary of State on the HR1 form. Okay, so when there is collective consultation, so let's assume that we've done that, we've got our reps in place, we're doing the collective consultation there with regular meetings. We also need to look at communicating individually with those members of staff who are going to have their contracts terminated for redundancy, because that's because as well as collective rights, they also would have individual rights to go to an employment tribunal and claim unfair dismissal. And to do that, they would need 2 years service first before they could bring an unfair dismissal claim. 2 years service is also needed in order to qualify for the statutory redundancy payment. So the employee could bring a claim for unfair dismissal once they have 2 years service. Redundancy is a potentially fair reason for dismissal, because as an employer, in order to succeed with a claim that an employee was fairly dismissed, you need to show a potentially fair reason, and you must follow a fair process. So if we just have a look at what a fair process might look like in a redundancy dismissal, that's one of the more tricky things, is looking at the appropriate selection pool. And quite often, employers try and draw the pool as narrowly as possible. Sometimes, particularly if it's not a site closure or a business closure, if it is reducing the number of people who do that particular job, try and draw the pool quite narrowly, because they consider it's least upsetting to the rest of the staff, don't want to cause disruption by having a lot of people involved in individual consultation. However, it's often in those cases that a tribunal hears evidence from the employee that, my role, it might have said this on my contract of employment, but actually I used to do a bit of this work, I used to work in that department sometimes, and therefore it's often advantageous both to the employee and shows fairness on the part of the employer if you have a wider selection pool. So if jobs are a bit more flexible and interchangeable, then drawing the selection pool as wide as is appropriate, as wide as possible, I think is would be kind of good advice there. So once you've identified the selection pool, and as I say, as wide as it needs to be, then we need to consult with the individuals in the pool, letting them know that there's potential for redundancies, how many may be affected, how many you need to reduce the workforce by, and then look at what criteria you're going to apply for selection. And again, this is one that gets, it can be one of the most sort of hotly debated areas of fairness in the employment tribunal. It's looking to have selection criteria which is as objective as possible. So trying to keep to things where you can point to evidence. So some people keep to absolutely strict evidential criteria using appraisals or attendance, looking at objective performance. Issues such as length of service tend not to be used now, occasionally only as a tiebreaker if all else is equal, because length of service could be age discriminatory, because that would mean usually younger people then don't have as long a service as older people, so could be age discriminatory on that basis. So looking at a selection criteria and selection process which is as objective as possible, not just somebody is difficult, so therefore they need to, they may be the ones selected. It's, well, what do we mean by difficult? Does that mean that they're not flexible in their in the roles that they'll perform, or not flexible over doing overtime, things like that? If we separate it out into more objective criteria, so undertakes overtime, willingness to undertake training and do other roles. So if we actually drill down to what we mean sometimes when we use these more subjective terms, then that is what a tribunal would want to see. Individuals then would need to have the opportunity to challenge their scores before any decision is made to terminate their employment, or to communicate to them that they've been selected for redundancy. So they would need to see how they've scored on the selection matrix. Now, what we would suggest that people do there is that the selection matrix is shown to the individual at one of the individual consultation meetings. They've got the opportunity to see where they come in the table, but they don't see other people's names, so they don't know who's above or below them in the list, but they can see where they sit and where their score is, so that they can either say, but I have got a certificate for this, or well, I can drive a forklift, or whatever it is. And that may mean that we actually go back and reevaluate and look at other people's scores, and may bring them up so that they're not the person selected. Also look at who is doing the scoring. Always useful to have more than one person do the either work performance scores, and then someone else who hasn't seen the initial set of scores to put in things that are purely objective from HR records. So attendance levels or number of disciplinary warnings, which may form part of the selection criteria, so that the two scoring sections don't see each other's scores and therefore can't influence them. It makes it fairer and more objective, and it is what a tribunal would expect to see on the scoring section there. So when we've got our scores, and they may have been challenged or not, we may have gone back and adjusted those. If we've identified the people who are provisionally selected, we might need to look then at whether we've got any suitable alternative employment for them. And again, suitable alternative employment does carry a subjective element to it. You know, who determines what is suitable? Well, both sides, both the employer and the employee, it has to be suitable. Usually, if it's a change of role and there's a change in the rate of pay, may not be suitable. An employee might decide to give it a try, and they've then got a 4-week trial period to try that role out, to see if it suits them and see if they are prepared to accept the reduced salary. And if they do, that's fine. Obviously, not redundant. If not, then the redundancy decision would stand. And dismissals then, if we follow that process and have our consultation meetings with the individual and both collectively, we would hope that we wouldn't get a claim, or if we did, we'd be in a good position to defend it. But dismissals would be automatically unfair if someone was selected for a reason connected to pregnancy, or because they'd refused to sign the working time opt-out agreement. So if we look then at alternatives to redundancy, and I'm sure in these times everyone will have looked at making all these cost-saving issues before we start looking at redundancy, but the ones the tribunal does expect to see ticked off the list are obviously suspending or restricting any recruitment, looking at removing any overtime, not renewing contractors' contracts, agency workers, looking to reduce or cease using agency workers, volunteers for redundancy in appropriate circumstances. So if we can call for volunteers rather than making compulsory redundancies, that's always helpful. Alternative vacancies, looking for suitable alternative employment and thinking more creatively about that in the wider business. Looking at whether there are any early retirement provisions. Obviously, the last two, anything that we can do in terms of temporary layoff, short-time working, and of course use of furlough. So if we do have to take the decision then to make an employee redundant, they need 2 years service at the date of dismissal. The statutory redundancy payment is then based on a formula with a factor for age, 1 week for each complete year of service, with 1.5 weeks for each year over the age of 42. So it's based on age, length of service and pay. Weeks pay is subject to the statutory cap of £538 a week. And that's used to calculate statutory redundancy payment. If you need to any support with that or need to look that up, the government website, you put in gov.uk redundancy calculator, you can put in all the details there, and that works out the statutory redundancy payment for you there. There's also then the statutory notice to pay, again, a week's actual pay, not capped, 1 week's pay for each complete year of service if people are being paid in lieu of notice and not being asked to work it. If you've got contractual redundancy payments which are higher, they're normally set out either in the contract or in your redundancy policy. So do have a look at those. But have you got redundancy payments or enhanced payments which are maybe not set out in a policy, but you've always done them, or you've done them on the last 3 or 4 occasions? They may have become implied by custom and practice, and it may be that, although you didn't intend to, you've actually become bound by those as a matter of contract. So you might need to look at what has gone on in the past, and what payments have been made to individuals in relation to redundancy on the last few occasions. And if people have been made enhanced awards, do be wary of any discrimination. Why have some people received enhanced awards and others not? Is it possible there that that could give rise to a discrimination claim if there's different characteristics between those individuals who've been made redundant, different genders, different ethnicities? Again, we just need to be cautious there if we're looking at making enhanced payments that are outside of policy. And then the tax considerations as to how redundancy payments are treated. If we look on the next slide there. Screen around. If we are making enhanced redundancy payments, then we need to look at how they're structured. The statutory redundancy payments or termination payments up to £30,000 can be made on a non-tax basis, and if those are statutory redundancy payments, if we're then giving enhanced payments as a goodwill gesture, they can also be eligible for the 30,000 limit. But we've got to be very careful that these are genuinely on account of redundancy. They are genuinely compensation for loss of employment or loss of office, that they're not a contractual payment. They're not a disguised retention bonus, for example, or a performance bonus disguised as a redundancy payment. They have to be a genuine payment on account of redundancy. So they can be taxable up to 30,000, and they can't be payment in lieu of notice, payment instead of notice. All notice payments are very clearly taxable, and HMRC is very hot on making sure it gets the tax there where tax is due. And any payment that is made to employees, say under a settlement agreement or as part of a redundancy negotiated package, which comes out at more than 30,000, will be taxable on any sum in excess of 30,000, and that's subject to the employee's normal highest tax rate there. So I think that's my time limit. And does anyone have to take any questions that might be in the box, or anyone's raised any issues? Okay.
Thank you very much, Julia. Sorry, I should have said at the outset, if anybody does have any questions, obviously feel free to pop them in the Q&A box or the chat box at the bottom of the screen. We have got a few, Julia, if you just bear with me.
Okay. Might move around because of the sunshine. Okay.
Yeah, the sun's altered in where I am as well. So, interesting one. When setting the criteria for selection, can the employer use attitude?
Yes, I do have this sometimes. I think we're looking at having objective criteria. So attitude, you might want to drill down with the individual manager who suggested attitude, what they actually mean. Attitude of itself is going to be highly subjective, isn't it? And is going to be something that could be challenged. But if we mean they're not very willing to, say, undertake other roles within the business that they're perfectly capable of, or they're not prepared to undertake overtime, or not prepared to be flexible. Those could be broken down to be objective criteria. So you could look at flexibility, willingness to undertake training to perform another role, say, willingness to say to be able to adjust start or finish time, or to work overtime. Again, dependent on individual circumstances. It may be that people have childcare arrangements and can't do that. But it's about, what does somebody mean when you say attitude? It could be that they mean so and so is always late. Well, that's a timekeeping point. So that is an objective criteria. So, are they always late? Is that what you mean by so and so has a somebody has a poor attitude? So it may be that actually what we mean by when we say attitude is something that we can break down and look at as an objective criteria. But putting attitude in itself on a selection form, I think, would get you into some difficulties in the tribunal.
Yeah. Brilliant, thank you. Another one for you. Is it safe to have a redundancy pool of one person if you are only looking to make the one person redundant?
Yes, yes, that's it. Yes, another good one. It's one of those. I'm going to sound like a real real lawyer, aren't I? An annoying answer. Well, it depends. It may be that it is genuinely a standalone position. Very often, though, you would find that if that person's job is considered redundant, there may be some small elements of that job that are going to other people. It may be that the title of whatever it is, manager, may be going within the business, but parts of that role will then be distributed to other members of staff. So in those circumstances, although the one role is going, some elements of the job will continue, and those people who receive a degree of that job, an element of that job in the future, when that person's role is gone, would also need to be put in the pool. It might be that they're discounted quite quickly, but you would need to show that you haven't automatically said, overseas operational manager, we don't do that anymore, so that role is going, without thinking, well, they did some invoicing for this, they did some internal work, they did a bit of liaison with national customers as well. So looking widely at what the person actually does, rather than just the job role, may well mean that if some elements of the job continue and other people get those elements of the job, then they too would need to be put in the selection pool.
Sure. And a final one for you, furlough related. If employees have been on furlough, can they be made redundant first?
Again, it's going to depend, isn't it? Because the person who's been on furlough may well be furloughed for a reason that the business is closed. We may think of front of house staff. Well, if the office is closed, then they're not required, so they're on furlough and can't work from home. However, as soon as the office opens again, then their role returns. So it may not be necessarily just because somebody's been on furlough that their role is actually redundant. So it is going to be sort of job specific, and may not mean automatically that because they've been furloughed for a time period whilst their role has taken a downturn, but they're necessarily the ones who are going to be selected under your redundancy criteria. You would still need to go through a proper and full selection process, rather than saying, well, because you've been furloughed, you're the one selected, because I think that would lead to you being on the wrong end of an unfair dismissal claim in the tribunal.
Sure. Well, that was that was brilliant. Thank you very much. Really, really informative. There aren't any more questions, so I think we'll leave it there. Thank you everybody who joined us this afternoon, and we hope to see you at the next webinar.